Hi everyone, my name's Ryan. I'm a solicitor at Dutton Gregory. Um, like Nick, you may well have seen me talk about Renters' Rights Bill generally before. I've appeared on a few webinars and podcasts talking about it, but the focus of today is going to be specifically at the student market. So some things will be a repetition of what we've heard before because some things impact the student market just as they impact kind of the broader PRS. But we're really going to drill down into a couple of the key concerns. Thank you to everyone who sent their questions over earlier. It's informed some of the slides that we've got today. I don't want to discourage anyone who has already sent in a question from asking another one. We do have some time for Q&A at the end. So what I'd like, or what I'm going to intend to do, is to cover some generalities. And then at the Q&A, if you have a specific problem you want to try and work through, I think it's quite helpful for everybody whenever I'm giving kind of training or webinars. It's I want people to get the most out of it. So by all accounts, if you've got a specific thing that you want to get some free legal advice on, then don't be shy, ask the question, and the worst that will happen is it just gets covered in the follow-up. So but hopefully I'm going to cover the broad stuff, and then we can drill down into some scenarios at the end. So yeah, I think that sets us up. Nick, can we go to the next slide, please? Well, so I want to start. I don't want to say controversially, but I do want to split this group into two because I'm conscious that the student market has a wide range of stakeholders. There is of course the purpose-built student accommodation sector, but not all the student accommodation sector is PBSA. So there is going to be potentially a split in how the student market is dealt with by the PRS. Word on the street, and this is not something that's in the Renters' Rights Bill, but certainly word on the street is that it's possible that PBSA providers can be exempt from the Housing Act 1988, which essentially means all of this stuff about renters' rights doesn't apply at all. The mechanism for doing that is that there's currently a list of tenancies that cannot be an assured tenancy set out in Schedule 1 of the Housing Act 1988. And in that section is currently a provision for university providers of accommodation, so essentially halls of residence, to not be considered as Housing Act tenancies. There's I've copied them. I've screenshotted the relevant legislation on the slide there. But basically, if we're looking at paragraph 2 of this, there is basically powers for the Secretary of State, which in this case is Angela Rayner, to broaden the scope of what is defined within this subsection. So subsection 8.1 is saying university providers, but subsection 8.2 is saying that can be broadened. So word on the street is that there could be a statutory instrument to expand student providers to include PBSA if they adhere to government codes of conduct. So that will mean none of the Renters' Rights Bill will apply to those providers either. And I will take just a moment to look at what that's going to look like for those people that fall within the exception. Then the rest of the webinar is going to be what happens if you don't fall within that exception. So hopefully between the two parts of this, we'll cover everybody. You either will fall into the exception or you won't. So by covering those two bits, we should be fine. But like I say, this is something that is already an existing power. It doesn't need to be part of the Renters' Rights Bill. And the only reference we get to this is in the Renters' Rights Bill guidance notes, which says that they're going to make PBSA exempt. There's no other mention of this exemption in the legislation. And like I say, it doesn't need to be mentioned in Renters' Rights. What it does require the government to do is to actually do the statutory instrument. So I probably wouldn't count my chickens until there is actually a statutory instrument laid before Parliament, which I imagine would probably come into force on the same day as Renters' Rights Bill, whenever that happens to be. But in principle, that shouldn't be an overly complicated instrument at all. It need only be, we're going to amend Schedule 1 Housing Act 1988 to include PBSA providers, so long as they comply with Government Code of Conduct. It doesn't need to be very long. So in that sense, it can probably be shipped out quite late in the process, even if it's not there currently. Next slide, please, Nick. So let's just tackle what it would look like if you did not have a Housing Act tenancy agreement. So as I say, in Schedule 1 of the Housing Act, you have all the reasons why a tenancy might not be an AST. And in future, that's going to be why it can't be an assured tenancy. In So currently you have ASTs and you have non-ASTs. They're also referred to as common law tenancy agreements. And the good thing about common law tenancy agreements is basically all of the regulation that applies to ASTs does not apply to non-ASTs. So whilst this particular webinar is focusing on what renters' rights bill might look like, if we're talking about an entire section of the student sector which currently has to provide ASTs, but may not have to provide ASTs in the future, then actually we're talking about requirements to provide or requirements to protect deposits going away. We're talking about different notices to currently. So we're talking about notice to quits and forfeiture notices rather than Section 8s and Section 21s. And the main benefit of those notices, generally speaking, it's easier to get possession and the notice periods are shorter. The Tenants Fees Act doesn't apply. So, for example, you could take a higher value deposit than you can currently take. Basically, the shackles are off. A lot of the legislation that's come in over the last 20 years has purely been targeted at ASTs and managing ASTs. Some things still apply. So, for example, you still need to get, say, a gas safety certificate, so need to be EPCs, because they apply to a broader class of landlords than just landlords on ASTs. But again, it's that link between gas safeties and EPCs and serving Section 21 notice that doesn't apply if you don't have an AST. You don't need to serve a gas safety or an EPC to serve a notice to quit, for example. So that will be quite liberating for the sector, I imagine. And it will also mean they can skirt around things like the particular parts of the Renters' Rights Bill which the sector has anxieties about. I say advance rent, periodic contracts, just simply won't apply to that sector at all. So if you can fall within that exception, and again, like I say, it's PBSE providers that adhere to Government Code of Conduct. I don't know how many PBSA providers already fall within that category, but if it requires you to sign up to something, I think it's probably well worth your while signing up to that code of conduct if you're looking for things to do between now and next year. And then that's essentially it, because now I want to focus on the other part of the sector, those who are not PBSA providers and who will very much have to deal with Renters' Rights Bill. If we can move to the next slide, please, Nick. And again, please. So the main areas of anxiety, as far as I see them, are to do with changes to how you're going to get paid, which is completely understandable, and it's an understandable anxiety for landlords and letting agents to have, given it's your entire business model. How do you get paid? So the main issue here is to do with rent in advance, and particularly the foreign student sector. So with let's say a UK student, you can get usually a UK guarantor. And if a student doesn't pay the rent, then you can go after the guarantor and then get your money that way. There are practical obstacles to enforcing a deed of guarantee outside of jurisdiction. And jurisdiction here, by the way, isn't all of the UK. It's England and Wales. That's the jurisdiction we're in. So if you have a guarantor based in Scotland, it's not that difficult to transfer an English and Welsh judgment into Scotland and then try and enforce it. But it is a hassle. It's another obstacle in terms of doing it. Similarly with Northern Ireland. They are easy in a sense of they all speak English and we have very similar laws in many ways, but it's an extra step to actually recovering the money. If you then have to enforce outside of the UK, it becomes an extra step harder because quite often there is then a language barrier. And then if you go beyond, say, let's say the EU, you have certain conventions in the EU, even though we've left it, it's still fairly consistent and relatively easy to enforce a judgment in the EU. I say relative compared to, for example, enforcing it in a non-English jurisdiction with different time zones, different codes of laws. If I was trying to enforce a debt in China, for example, I would find it very difficult to even know where to start, if I'm being frank. You may need to seek some specific legal advice about how to do that. And frankly, it may not be worth the cost of doing it. So we have to think about, in a world where there is no rent in advance, how do we let to foreign students without guarantors? Now, I know some providers already do this model, which is simply, but they just sign them up anyway. They sign up foreign guarantors knowing full well that that piece of paper is not worth the paper it's written on. and then you essentially chalk that up as the cost of doing business. So if you think, for example, there might be a 2% spoilage rate, 2% of foreign students might not pay their rent. If that allows you to take the other 98% rent without disrupting the business model, then you might just have to accept that as being a way of doing it. The alternative would be just not to let foreign students at all, but I really think that would be so disruptive to a lot of people's business models, particularly given that so many universities specifically target foreign students because they pay the most fees. Um, that's I don't think it would be a viable business model. I mean, it's not for me to tell you, but I don't think it would be a viable business model to exclude foreign students from your lets entirely. You've got to figure out how you can get it to work. And like I say, most students are pretty good payers. A lot of people, if you just imagine yourself, if you were going to a foreign country to study, you probably would be a law-abiding student. You would be paying your rent. You know your obligations. And those who don't, then like I say, the cost of doing business, if it allows you to tap into that market of mostly good tenants, maybe that's worth considering. I think it's something that the PBSA are going to be more easily able to absorb than individual landlords. So if you've only got a couple of properties, can you take that risk? Maybe you can't. It's a similar sort of thing with rental periods. So as we know, a lot of students pay their rent termly. So you often have, say, 3 or 6 varying amounts of payments due over the course of a year. You might have some special rules about summer as well. But in the future, it's only going to be monthly payments at the absolute most that you're going to be able to demand. Now, I think one of the questions we got in advance was to do with what if the tenant just pays termly? There's nothing at all to stop you taking advance payment. Basically, there's nothing to stop the tenant from making a payment in credit, putting the account in credit so that they don't have to pay future month's rent. That's absolutely fine. The only thing the law prevents you from doing is demanding that they do it in a certain way. So essentially, if the tenant says, I want to pay 3 months rent up front, or if they choose to pay 12 months rent up front, that's absolutely fine if it's their choice to do it. I don't know how you can realistically get them to do it without it being by some kind of force. But ultimately, if you have some very generous or willing tenants who just want to pay the money up front and not have to deal with it anymore, that might be a way around it. If we're talking about the kind of the foreign guarantor workaround as well, is that essentially if a person can't sign up you sign someone up as a guarantor, you can't demand that the student pays all that lump sum up front. But it could well be part of the discussion that if the guarantor simply pays the whole rent up front, then there's no risk at all of any of the tenant failing to pay the rent during the term. So yeah, you might have to be silver-tongued to an extent to see if there's any way you can get the tenant to volunteer to pay, because if they're not volunteering, you can't force the issue at all. Next slide, please, Nick. So one of the key questions that came through multiple times was, what can we do right now? And it's a tricky question to answer because I don't really think there's that much you can do. So, but there's a couple of assumptions that you might want to bear in mind. We don't yet know the final law because it hasn't passed Parliament yet, but we can be sure that 95% of that bill as written is not going to be changed, particularly the bits which are going to affect how you're taking payment. So the rent in advance question was raised at the second reading of the Renters' Rights Bill, and Matthew Pennycook, the housing minister, stood up and said that he thought it was clear, but if it wasn't clear, he would maybe make some steps to make it clear that you can't take advance payment of rent. So there might be some clarification of our understanding of it, but I don't think we're going to see anything between now and the law passing that's fundamentally going to reimagine the bill. Labour have had a fair old time to work on this. They obviously had the renters reform bill to base a lot of this stuff on. So the first draft is going to resemble the final draft in pretty much all cases. So in terms of what you could do now, if we say that we know what it's going to look like, you can certainly get tenancy agreements in place. So I've prepared updated templates already for a few stakeholders, and It wasn't too difficult, if I'm being honest. Whilst Renters' Rights Bill is going to completely reimagine the PRS, what changes in your contract is actually quite minimal. And in fact, if I'm to say three things off the top of my head, it would be removal of fixed terms. So you have a purely periodic contract. You're removing rent increase clauses, which for student lets, you probably didn't rely on too much anyway, because we really are talking about 12-month cycles, aren't we? And then the other aspect of this is pet clauses. I don't imagine the pet provisions in the Renters' Rights Bill are going to change any meaningful way. So what that means is you can put together pet clauses now, and you can sign up tenants on contracts that will be compliant in the future, on the understanding that the legislation is unlikely to majorly change. At least I don't think it's going to impact on those three things, certainly, between now and the law coming into force. So another aspect of this, another question that really came up often was to do with what happens if we sign up to an agreement that might not be compliant in the future. Let's say, for example, you've got a rent increase clause in your contract. What happens then? Well, the general legal principle here is statute overrides contract. So if statute says, legislation says that you can't have a rent increase clause in your contract, and you've got one, well, simply put, that clause is null and void. You're not going to be able to actually enforce that clause. As long as you understand that, there's no reason why you need to there's no reason why you need to say amend your contracts or serve new contracts if they've already been signed up to a contract which includes a rent increase clause. You just simply have to mentally erase that clause from your mind, because you're not going to be able to rely on it after the law comes into force. There also doesn't seem to be any requirement as of yet. So I do think this is something that could change, but doesn't seem to be any requirement of yet to give the tenants anything new after the law comes into force. So those of you who operate in Wales may still have PTSD from when Rentocare Wales came into force in December 2022. And they will remember the conversion contract, which is basically a list of things you had to, well, basically a list of clauses that you had to send to a tenant to basically say, these are the new laws that apply. We might get something similar in England. But I think it might take the form of, say, a how to rent guide. Not that anyone reads it, but I can't imagine many Welsh tenants actually read the conversion contract either, because they were about 40 pages of extra clauses. And I think the English, the Renters' Rights Bill is a far softer rework of what exists than what they had in Wales. So in that sense, I don't think there's actually that many pages to print out. But there's currently no requirement at all to do anything other than just get them to sign up to a contract. If you get them to sign up to a contract now, you don't have to get them to sign up to a new contract or a different contract in the future. I know that some stakeholders are keeping their powder dry and not signing anyone up until close to the time. That's perfectly fine. But like I say, I don't think it's on the basis that we know what the law is going to look like. I don't know what you're waiting for, really, because nothing's going to fundamentally change. So I think in the interest of getting people signed up now, it probably is in your business interest to do that rather than kick the can down the road and end up saying, "Oh yeah, we could have just done this months ago." That's my opinion on it. Is I don't think there's any real reason to wait. I did see there was NRLA advice about the words of subject to contract, which is basically it basically means that the contract doesn't take effect, doesn't become binding until it actually starts. So in that sense, you can sign them up to something, and then either party can pull out between now and then. Again, that poses the problem that the tenant might pull out. You usually want to bind the tenant in. That's kind of the purpose of signing them up early, is that you can guarantee that they have to perform the contract. If they don't turn up, they're still bound. Subject to contract gives the tenant scope to wiggle out of it. So it's not bad advice if you're at all concerned that the law might change the Renters' Rights Bill might change in a drastic way. It might be sensible to say subject to contract, we'll give you these agreements, but we might have to change them between now and then. But like I say, I truly don't think it's necessary to do that. And in fact, I think the business impetus here might just be to sign people up on the basis that you take a little leap of faith, but I think we know what the law is going to look like. So I wouldn't be too concerned about signing things up subject to contract. Something that landlords are going to have to think about, though, is joint and several tenancies versus room lets. Now, this is something that I've seen come up quite a lot, and this is all linked to a tenant's notice. So, as a recap, tenants are able to give 2 months' notice at any time. So they can sign up to a tenancy, move in, and immediately give 2 months notice to end the tenancy in 2 months' time. That's going to create a lot of instability because there's really two main ways in which tenants might want to use this in a way that they can't currently use it. So you have certain tenants who just decide uni isn't for them. And this happens fairly frequently. You get there and you miss home, you miss your mom cooking for you and doing all your laundry, and you decide you can't stomach it anymore, so you leave. That tenant would be able to give notice to expire in, October, November, depends when you sign them up or when tenancy starts, I suppose. But that they can give notice 2 months at any time. So that particular tenant would be able to would create a void period. How do you alleviate that void period? Now, there's some people who think it would be sensible to have them all on joint as several tenancies. On the basis, if you have, say, 4 tenants all on the same tenancy, then if one of them leaves, one of them gives notice to quit and severs their liability, you still have 3 other tenants there who are liable. And let's be honest here, we're talking about guarantors here, aren't we, being liable for the remainder of the contract. The issue, as I see it, is that I don't think that's any better than having them on an individual let, because the individual let would also have a guarantor supporting it. So if this tenant decides they can give notice, you may just have to absorb the void period. Whereas if you have these 3 tenants, they might also leave if they're exposed to serious rent arrears. If they're having to share the burden of paying this extra person's tenancy between a lot of them, they might also say, and yeah, they would be able to leave in accordance with the tenant's notice to quit as well. We're talking about an individual giving notice of leaving, but that individual tenant is technically ending the entire tenancy. So the other tenants could leave as well with that. So is it worth maybe containing the loss to a single room, or is it worth just saying, well, we all go down together? Either all of them leave, in which case, you've got an entire unit spare, or you could have 3 tenants who just have to suffer and find the rent between a lot of them to pay the whole rent that's due. The only other thing I'll say about joint and several versus room lets, and you'll forgive me here because I did have something to say. I had a question, and it's fallen off the tip of my tongue, I'm afraid. If it's important, I'll certainly come back to it. But yeah, it was this. Practically speaking, again, I used a scenario which is that a student signs up to uni and simply doesn't like it anymore. That kind of tenant isn't necessarily going to be entering into a contract jointly with other tenants. They're usually going to be by themselves because they don't know anybody at that stage. So yes, you have dropouts. I don't think there's going to necessarily be a way to protect against dropouts, particularly in the first year. So in that sense, you're only really ever going to be able to sign those up onto room lets just for practical purposes. It's only when you get kind of further into the years, your second years and third years, that you get these joint or several tenancies where people actually choose to want to live together. So it simply may well be the case that you don't have the option of signing people up on joint and several contracts. You only have room lets you can use. Can we go to the next slide, please? So I want to talk about ground 4A. Ground 4A is the specific student possession ground. It has many different restrictions on it, but ultimately this is the only mechanism student landlords have got to ensure that they get vacant possession by the next academic year. I fully expect every student landlord to be serving a wave of these in the next academic year. I don't think it will actually be necessary to serve a wave of these in every single academic year. But I do think, particularly if you're a letting agent, you don't want to end up with egg on your face because you didn't serve a notice and actually the tenants didn't end up leaving. I think most tenants will leave of their own accord. And they'll leave in the second scenario of tenants giving notice, which is that they can give notice to coincide with the end of their academic year, which usually ends earlier than June or July. So if they give their notice to end, say, the day after their final exam, you've got a void period over the summer, but and there isn't really anything that you can do about that. But it does mean that students usually are going to be leaving fairly consistently because they don't want to remain liable. I think the purely periodic contract, rather than just say a fixed term, which ends automatically if the tenants leave at the end of their fixed term, is going to harm a lot of students because I don't think a lot of them are going to remember to serve notice. And even if they're not occupying the property, they are going to remain liable for the rent. So I think what will actually be interesting is not so much whether or not landlords decide to serve a ground 4A notice, which like I said, I really think it would be prudent to do it, even if you think the tenants are probably going to leave. I think it's really interesting to see how many tenants remember to serve notice to quit when they're meant to. Um, Now, again, pragmatically here, you might say, look, I just want the property back. So if they forget to serve notice to quit, I'm quite happy to accept a surrender. That's fine. But students are disorganized. We know that. It's I think it would be sensible not to rely on a student remembering to serve notice. And I think it would be helpful to remind them that our intention is to serve a notice to expire, and they should leave in accordance with that notice. So there's a few restrictions. I'm just going to go through it in order, but you've got ground 4A on the right hand side of your screen there. You basically need to satisfy 5 different conditions. The first condition is that the property has to be a HMO or part of HMO. Now, it's important for me to say here that PBSA, great big blocks of flats, can still be HMOs. We're not necessarily talking about converted houses that have been turned into 5, 6 separate little roomlets. You can have HMOs for quite large blocks as well. So I do think it's a bit of an oversight by student providers to assume it doesn't apply to them at all. But either way, what I'm trying to say here is that even if you've got big blocks, you may still be able to satisfy the HMO criteria. So that's step one. It's got to be a HMO. The tenant has to meet the student test, which is defined a little bit later on in this section. But basically, they either have to be a student or the landlord must reasonably believe that they are going to become a student. So this is really a referencing point, and I would like to think that most student providers are actually checking to see that a person is likely going to become a student anyway. So again, if you're checking at referencing level that someone is going to become a student, maybe you require some notice of acceptance from the university. This person's going to start a course before you let to them. But that way you can satisfy the student test, even if they subsequently do not become a student. I think that was going to be quite a niche scenario, to be honest. It's someone you expect to become a student but isn't going to be. But at the same time, if you're checking anyway for their student status, then you probably are satisfying this criteria as well. Then we have the third requirement, which is basically giving pre-notice. So you have to give a tenant notice before they enter into the tenancy that you intend to end the tenancy. And so there's wording here, and there isn't prescribed wording for what the notice must be, but I wouldn't want to reinvent the wheel with this, particularly since we're talking about doing this for the first time. We want to make sure it's right. So I would be suggesting that we copy key parts of this paragraph, which is paragraph C on the slide, which is basically, you are a tenant and you're a student. We need the property back by the next academic year because we intend to let it to students. That means that you have to leave, and that we're going to give you a notice which is going to expire between the 1st of June and the 30th of September at some point in the next academic year. So you're putting them on notice that you're going to serve a notice. It's important to say, and this is a question that has come in, what happens if you're signing up students now for a tenancy that might start after this comes into effect? There is a transitional provision here in Schedule 6 of the Renters' Rights Bill that basically says that you can give that written statement within 1 month of the Renters' Rights Bill coming into force. So you can't give it now because the Renters' Rights Bill hasn't come into force yet. But you can draft up the template email, and I would really suggest that you do that now, just so it's one less thing to do when it actually comes into force. So it's ready to go day one of when Renters' Rights Bill comes in. You send out that email to everybody. As long as you send out that email to everybody within the first month of Renters' Rights Bill coming into force, you will be able to serve ground 4A at some subsequent point. So if we're looking for things to do right now, draft that email, get that done. It doesn't, like I say, you're not reinventing the wheel here. It doesn't need to be particularly long or onerous. It just needs to satisfy the criteria, which is that basically they're a student. You need the property back to let to more students. You're going to serve them with a notice at some point. Then we have the fourth criteria, which is that if you're serving a notice, so ground 4A is a 4-month notice period, the notice must end between 1st of June and 30th of September. Now, tactically speaking here, you might want to cut this as fine as you can possibly cut it, because like I said, I don't think a lot of students are going to remember to serve their notices to quit. So in that sense, if you can end the tenancy as close to the line as you possibly can, take into account the fact you'll probably need to do some redecoration. There may be some stuff that you need to get done before the new cohort comes in. You will be able to extract the maximum rental revenue from your existing cohort. You're playing chicken there, I would say, because you are relying on the students to leave it in an acceptable condition. Ultimately, if you're giving yourself a week to turn around a property that might well have been trashed, you are going to be cutting things very fine and you're playing with fire. So I think this is really just don't want to say bravery is the right word because I don't think it's brave. It might just be a a recklessness decision. How reckless are you feeling? I think it might be sensible to give, say, at least a month. And again, tenants can give their own notice. So you give them 4 months notice. There's nothing to stop a tenant from giving their 2 month notice period to end. As long as they give their notice validly, their tenants, they can end that tenancy by themselves. And there's nothing you can do about that ultimately. I think, like I say, the first academic year of this coming into force, everyone's going to have to serve these notices because I just think you can look ridiculous if you don't. And it may well be the case that you don't have to send them out in the future. And I say that because as a practitioner, the bread and butter work that I do is evictions, and I've got lots of student providers as clients. And I will say I can count on my hands how many times I've had to actually evict a student. It's not very many. They usually just go. They want to go. They don't want to be responsible for rent. They just want to go home over the summer. So it doesn't usually come up. It usually comes up in the context of antisocial behaviour. But again, I haven't actually had to evict many students for antisocial behaviour. If you give them a notice saying we're going to evict you, they quite often leave. But my personal anecdote here is that I've got clients who are student providers, but I've also got at the other end of the spectrum, essentially like the care accommodation providers, like the over 65 residential units. And I've had to evict many more of the pensioner crowd for antisocial behaviour, rent arrears, all this kind of stuff, and I've had to evict students. And I'm pretty sure that the student market is much bigger. So for my own personal numbers, it's the old ones that the troublemakers, not the students. The students generally are, uh, despite what reputation might have for partying, they generally go when you tell them to go. Anyway, and then the fifth requirement of this is that the landlord must intend to re-let to students. So long as they intend to let again to students, and there isn't really any you don't need any evidence to support this. Some of the other grounds in Renters' Rights Bill are talk about a landlord's intention. A landlord's intention can just be a thought. Okay, I intend to do it. They can change their mind. They're not obliged to, but it's a criteria of the ground that you have to say that you are going to intend to re-let to students at some point in the future. So long as you've got those 5 conditions in place, you can serve ground 4A. Like I say, 4 month notice period. So if we're talking about cutting it on the 1st of June, then we're talking about serving a notice on the 1st of February. You can give more than 4 months notice. So a Section 8 notice, which is the vehicle for ground 4A, a Section 8 notice has a validity period of 12 months. So there's nothing at all to stop you from serving this notice in October if you wanted to. It's just that you need to give at least 4 months. So again, my advice here, if we're thinking about things that you can do now to take the stress off yourself, don't leave it till February. Don't leave it till March. It's better to get these things out in good time so that you're not rushing around having to send out hundreds of thousands of them and getting them all crammed into the postbox. Yeah, I think that's basically all there is to say about ground 4A. As I say, I'm expecting to serve a lot of these, but I'm not expecting to necessarily serve a lot of them in the future because I think people will see that this is to quell the anxiety about periodic contracts. And what we really have to see is whether or not student behaviour is fundamentally changed by the shift from fixed term to periodic. I don't think it will be. So I think that the incentive for a student to leave over summer is still there. So I think a lot of them will just go. A lot of them will know their rights and know that they can actually serve notice earlier than when they would otherwise be committed to under a fixed term. Yeah, we'll just have to see how students respond. If student behavior shifts en masse, then yeah, it might just become part of the annual cycle as you sign them up, wait a month, serve them with this notice, and then it's just part of it. And yeah, if they don't leave, practically speaking, you're not going to be able to actually evict this tenant before the next academic year because of the time it takes to actually issue proceedings. So even if you had a notice that say expired on the 1st of June, if you issue proceedings on the 2nd of June, you wouldn't get a possession order by the September. Or so you wouldn't be you might get possession order, you wouldn't necessarily get an eviction date. Like I say, it's not common to evict students anyway. I think they just need to be told a date when they're expected to leave. They probably will. But if a student doesn't leave and they actually want their periodic assured tenancy, which they're entitled to, you're going to have to actually end up evicting them, and that is going to create a void period, either because you can't get the whole of the property back, or because you're going to evict them at some point in the next academic year, and you won't be able to relet that property. It'll create a problem. I'm afraid there really isn't anything we can do about that other than just hope and pray that our students know when they need to leave and are sensible about it. Go for the next slide, please, Nick. Great. So I think I've covered most of this. I did leave a few things. I didn't answer all of the questions because I thought we might want to have some meat on the bone in terms of this Q&A. But Nick, have you been reading the questions? Have you got some questions to throw at me?
Thanks very much, Ryan. That was great. Yeah, I've got quite a few to go through, so we'll pick them out. The so one of them, if we go back to this idea of potentially going for individual lets rather than joint and several contracts.
Mm.
So I think some people are thinking, okay, that might be a bit simpler to have an individual let because one person can't basically end the whole tenancy. Um, One of the questions that's come in is though, there's going to be some restrictions on that. For example, if the license requires you to have a joint contract rather than individual contracts, and could you just touch on that and also how common that would be in your view?
Yeah, so I assume what we're talking about here is from time to time, I seem to see that this comes up all the time for Nottingham City Council. I always seem to see them putting all these kinds of restrictions and requirements in place. But I'm sure other councils have their own favourite clauses to put in. Um, Ultimately, if some third party who has the power to penalise you, for example, a local authority, says that you have to have certain provisions in your contract, you cannot create roomlets, you can only do it this way, then I think you're going to have to go with the flow on that one. Um, it's up to you to decide if you want to challenge that, but I think that does restrict your choice, and in that sense, if you've only got a choice of two, the choice has been made for you, hasn't it?
Yeah. But the point is that's on a case by case example, a case by case point. So in the widest sense, people can generally choose between the type of contract that they have, i.e., joint or individual.
Yeah, it's not a common restriction. It's just something that I imagine a local authority could do should they choose to do it. You do question what the benefit of it is, but it's up to them. Ultimately, it's up to them. And since they have the power to levy fines and all kinds of things on you, I can't possibly advise you to take what they say lightly.
Yes, okay. So a relatively simple one here, Ryan, I think. So someone's asked what happens if you've got a one or two bedroom property in relation to the ability to serve the notice.
Mhm. So if it's a two bed, it could still be a HMO. Um, and indeed, even if it's because all you need for a HMO is two households, it doesn't need to be a licensable HMO. So there's a distinction here, which is basically if it's a house under multiple occupancy, if you have two households, it might be a mandatory license, it might be an additional license as well as that. But if we were just meeting that basic definition of two households, a two bed can be HMO. So I think really the question here is if you have a one bed property, you are stuck, I'm afraid, because that property cannot be a HMO.
Okay, no, that's helpful because I think um, yeah, there are quite a lot of two bed student properties, and if there are then some that are HMOs, then that is handy. Um, One is a bit of a practical one, so I can't see any issues here, but it'd be interesting to hear your views. So some of the uh, landlords are asking, can I bring forward my tenancy start date? So if I bring forward my tenancy start date to May, that mitigates my risk towards the end of the tenancy when I'm thinking people are going to potentially leave. Is
Mhm.
there any kind of issue or restriction with that, Ryan?
No, other than I suppose it's just subject to market forces, isn't it? Now, do you think the student would want a tenancy to start in May when they're not intending to occupy? I mean, very well, if we're talking about first years, for example, they're still going to be at college in May, aren't they? They're not necessarily going to be in the same city as the place where the tenancy is due to start. So are they going to want that product? No. if it's the only, I mean, I'm not suggesting we all create a cabal or a monopoly or anything like that. But if everybody offered that product, then there simply wouldn't be any choice in the matter. That would simply be, again, I've used the phrase already, the cost of doing business. If a student wants a student accommodation for the next academic year, they're going to need to sign up in May. Again, bearing in mind here, first years in particular, I said they'd be at college. They might have exam results back. They might not even know what uni they're going to. How can they realistic if you've got a student, say, with three different choices, they don't know where they're going to go. They might end up in clearing. They can't possibly commit to a tenancy for that. I mean, admittedly, we're talking about first years here. Second years and third years might be a bit more stable. Um, but yeah, that's totally possible. But if everybody offered tenancies to start in May, then what can the student do other than accept it?
Okay, handy. So there's nothing to stop people doing that. The other question is one we touched on before. Actually, I'd just like to expand on it. So this is the sort of idea of having slightly different rental amounts. So one of the landlords says, is it acceptable to say have 10 months at a higher rate and then the
Mm.
last two at a lower rate, so that you mitigate again that risk that everyone's concerned about those, those early leavers, if you like.
Yeah.
You kind of front end your tenancy. Is that possible?
Well, the weird thing is this isn't a renters' rights bill question at all. This is a tenant fees act question, and in principle, that's already prohibited. You can't have a period which is higher than a subsequent rental period. The idea is to prevent like front loading of rent, but it seems weird to me, instinctively weird, that a landlord couldn't generously agree not to charge full rent for a period of time. Um, it sounds daft, to be honest, but if you read the Tenant Fees Act, that's exactly what it prohibits. So, on the basis it isn't currently allowed, it won't be allowed in the future either. So, no, if you do it, you do it. But bear in mind, it is a technical breach of the Tenant Fees Act.
Yeah, so technically it's not allowed, but giving 2 months rent free at the end, would that be acceptable?
No, so again, we're talking if we're talking about the way in which it's structured is if you have a rental period which is higher in value than a subsequent rental period. So if we just say £1,000, £900 for 2 different months, the £100 difference in the first month is a prohibited payment. You're basically capped at whatever the lowest rental period is for the first 12 months of a tenancy. Now we're only really talking about the first 12 months of a tenancy with student lets. So the clever workaround might be as if there was a way to extend it beyond 12 months, but it wouldn't quite sync up with other tenancies that they might want to take up. So I don't think there's a way to do it that way. If we're talking about a purely 12-month tenancy, but bear in mind we don't have fixed terms at all here, the contract would need to specify months 1 to 10 are X, months 11 to 12 are free. That's prohibited. And the way in which it works, I gave the £1,000 and £900 example, that the £100 difference is prohibited payment. It's basically the difference between the higher and the lower values. The entire rent is a prohibited payment because the difference between the X payment and zero is going to be X. Yeah, it seems strange that landlord can't be generous. The landlord has to charge full rent.
Yes, fair enough. I don't want to go too far down this one, but then a question springs to mind because I know some PBSAs do something similar. I assume it is acceptable, though, to say that you get a refund of your rent in the last 2 months. So as long as the amounts that you're charging are consistent, you could
Hmm.
say that you effectively get your rent refunded for a month or something along those lines, as
Yes,
long as you're not
so
varying the rent.
I think that's the way around it is if you have you can't have anything in your contract saying that the basically months 10, 11 are free because that's altering the rental periods. But if you
Yes.
basically just charge the full rent and then again you just give it back at the time, it can't be like a premeditated contractual arrangement. There's nothing to stop a landlord from just doing that. And again, I've kind of said it a few times. It feels like there's going to be circumstances here where landlords and tenants are just going to have little chats between themselves about the way in which rent's going to be paid, and everyone's going to basically continue as normal. I can see that for happening in loads of different circumstances. Tenants aren't going to know. The relevant organisations who are going to govern this, so local authorities in most cases, are probably never going to find out that there's been a breach going on. So I think there's going to be a significant part of the sector which is just going to carry on. Um, it's my job to tell you what the law is. It's your job to do your job. So how you choose to interpret that is up to you.
Great, thanks, Ryan. So the other question that comes up quite a lot is how to become recognised as a PBSA. So, I mean, I think as far as I understand it, there are certain criteria before you can be recognised as a PBSA, and it relates to the number of rooms and facilities. Is that your understanding?
I think what might be helpful is if we perhaps provide some written bits for
Yes.
for the attendees, because I think it's going to be quite a hot YouTube, hot Google topic in the next few months. How do we get the how to reach this threshold? So maybe if we just maybe link some government guidance on it, then they can have something that they can get started with.
Yes, I believe there is certain guidance from the ANUK code, for example, and it does relate to the number of rooms in a single property, so we can share that. Just another practical one. And this is just to share. So, in relation to kind of guarantors for international students, someone's flagged up. There are services that landlords can use, House in Hand, for example,
Mm.
who will act as a guarantor for international students, and so there are mechanisms to sort of facilitate international students having a guarantor.
Hmm. Yes. So the important thing with the Tenant Fees Act, because again, this is a Tenant Fees Act question, really, is you cannot ever require someone to make a payment to a third party. So it's an insurance product, basically. The tenant has to make a payment to Housing Hand or other suppliers are available, and it's up to so what you always have to have is the choice. And unfortunately, the choice in this case is going to be quite blunt, which is that you can't demand all the rent up front. That's not a choice because you can't legally demand that anymore. Um, the other option is basically they don't take the tenancy. Is that even a choice? I don't know if that is actually a choice. Um, it's a really tricky thing. I don't know how you're actually going to force a tenant to I don't know how you're going to give them a fair choice over using Housing Hand or not taking the tenancy because I just think the other choice can't be not taking the tenancy. So this works. If I can expand on this slightly, there is a pre-existing industry about deposit alternatives. And the key word there is alternatives. You can pay 5 weeks rent up front, or you can pay 50 quid a month to this provider and you don't have to pay it up front. There is a choice. One of those choices isn't you can't take the tenancy. That isn't the choice. It's do you pay this way or do you pay this way? With the guarantor replacements, I don't know what the alternative is.
Yeah, no, it's an interesting area. I think the other comment I would make, because I have previously run a guarantor services, international students are really good tenants, and actually
Yes.
they rarely leave. They pay high fees, so they're very invested in their course because they'll typically
Hmm.
be paying 20 odd thousand pounds a year. So they are actually good tenants. So I think sometimes the point you made about rarely doing evictions in the student sector, I think sometimes the kind of perception of risk is higher than the reality, if that makes sense.
Yeah, indeed. It might just be that we haven't actually tested the waters in this, really, because if you've got a foreign student, why not take all the rent up front? Yeah, you've currently got the options to do that. Why not do it? But like I say, I know for a fact some providers do take foreign guarantors on the basis of the tenant paying rent like a normal tenant.
Yes.
And if they don't pay, well, you absorb that.
Yep. Understood. Okay. So one of the attendees have asked, can a license agreement be used in the PRS, basically? So can they use a license agreement?
So yes, but it's a really tricky thing to do because you can't just call a tenants agreement a license and expect it to be treated as such in a court. There's quite famous case law and it's called Street versus Bamford, which is basically someone trying to do exactly that. They were trying to get around the provisions of the Rent Act by saying, "Oh, it's not a rent act tenancy, it's just a license." But nothing that they did held nothing they didn't behave in any different way, so basically the court said it doesn't matter what you call the thing, it's what it legally is. So in this case, how do you create a license? You create a license by there's two mechanisms for doing it. One is by providing a service. So if you stay in a hotel, you are there under a license, and they provide a service, which means they can go into your room and do some clean. I mean, yeah, fine, you can put a cardboard thing on the door holder, can't you? But legally, they could go into that room if they wanted to, cardboard or not. They can go in. They That means you don't have exclusive possession of that room. So if students don't have exclusive possession of their room. If you provide a cleaning service or a B&B or something, like you go there with food every single day, you provide something extra that you perhaps you're not currently providing, you can create a license. The benefit of a license is akin to what I was talking about earlier with the PBSA being exempt from renters' rights. If you have a non-housing act agreement, you don't have to register the deposit. You can still serve notices to end it. There's all kinds of advantages to creating a license. The main downside is you actually have to provide that service, and that might be quite logistically difficult, might be quite expensive. I assume there's reasons why a lot of people don't currently do it, because even now it's still an advantage compared to creating an AST. It's better to create a license for landlords, but to do that they'd have to really look at their business model. The other way to do it is to enter into a contract with the express understanding that they are not creating a tenancy. Now, this is easier to do on short-term let. So a lot of student providers sometimes let out. I know universities do it quite often. They let out their halls over summer as holiday accommodation. There's no expectation on the person entering that accommodation that they are going to be staying there as a tenant. They are there purely for a short time, perhaps a good time. But they don't. But they're not necessarily going to expect to be a tenant. If you can enter into contracts with tenants who, sorry, I shouldn't say tenants, enter into contracts with people who do not expect to become tenants, then you might be able to justifiably say everyone agreed that this was a license at the outset. But I don't know why any student would expect it to be a license unless there is a real short-term element to them staying. I think that's only going to work if we're talking about 2 or 3 months, perhaps over summer, as like like the holiday component that might push it over the edge conceivably. But I don't see how in term time you can let to a student and say it's a license unless you are providing that service that kind of encroaches on their right to exclusive possession.
Yeah, so just so we're clear, so technically, if you were cleaning the rooms, you could make that a license, and then
Yes, yeah.
therefore that would be technically exempt from this new. But okay, helpful.
And you can
So
do that now, I should say. Again, this
yes,
isn't a renters' rights thing. You can do that right now if you wanted to. And I assume the reason why you're not is because it's a complete hassle.
yes, so someone will have to clean the rooms. Yeah,
Yeah.
yeah. Okay, so I know you covered this, but the questions come up a couple of times, so I'm just going to go
Sure.
briefly over it. So people are saying, so one of the questions is, can I use my AST as it stands? And I think what you were saying is, yes, absolutely.
Yeah, yeah.
You can issue your AST as it stands now, and really, your advice was you don't. It's probably not a great idea to issue it subject to contract.
Yeah, I see downsides to issuing it subject to contract because, like I say, I don't think anything's going to really change. That means that you can prepare a contract anticipating what's going to be in the law. Like I say, if you take out fixed terms, you take out rent increase clauses, you put some clauses in to do with pets, that's going to be an RRB compliant tenancy agreement in the future. And it's one that you can use right now. You can create an assured tenancy right now if you want to. So yeah, on that basis, I think it's better just to sign people up, get them committed, than it would be to leave things open-ended with subject to contract. That's my take on it. But like if you give them an AST to sign, and it's an AST which isn't going to exist in the future, it's got a rent increase clause there, and that's not going to be allowed in the future. The law is simply going to override those clauses. Like I say, statute overrides contract. If your contractual clauses don't work anymore, then they simply cease to exist on the law coming into effect. So you don't need to worry about it.
Yeah, okay. So just so I'm clear on that, Ryan, so it would only be the clauses that don't apply. The rest of the contract would still apply. So
Yeah, absolutely.
it is only those particular clauses. I think that's really, really helpful advice because I think quite a lot of the nervousness in the sector is, should I be doing this now? And it
Mm.
sounds like it's absolutely fine, but bear in mind any of those clauses that are going to be affected by this won't apply once it's introduced. But it's not going to cause anybody any issues.
Yeah, yeah, exactly. But the law will just take effect. So if we're talking about yeah, if there's any provision there about landlord service section 21, it won't exist anymore. But you have everything else in there will survive. It will only be the clauses which are contradicted by the change in legislation that will be affected.
Great stuff. Okay, somebody else has asked, what about if and this does come up, if you've got a mixed household of students and non-students, I guess that's going to be an issue under the new guideline, or under
Hmm.
renters' rights in terms of getting possession in line with the academic year. That's not
Yeah,
going to be
absolutely.
possible.
I don't know how easy it is to get my slides back up, but in the wording of ground 4A, they all have to be students.
Okay.
So a mixed household is, again, you can't serve ground 4A, so you have to really consider, am I going to let to a mixed household? Probably not.
Okay. Thank you. So we have got quite a few more questions, but I'm conscious that an hour is nearly up. So um,
I'm happy to stay for a little bit longer if the people demand it, that's fine.
yeah, okay. I think some of these we can cover off, and some of them you have covered. So you have covered this a bit, I think, but I think someone's asked is what happens if someone simply refuses to leave, and I guess that's really the same as the current situation, isn't it? If somebody refuses to leave, they refuse to leave, and you have to get them
Yeah,
to leave.
except the only difference is currently you probably wouldn't have given them a Section 21 notice either, would you? Because you would be expecting them to just leave at the end of their fixed term, which is what most students do. Like I say, I think this has really come down to will student behaviour change as a result of being given periodic contracts? And I think that by serving the pre-notice, serving round 4A to say we expect you to leave on this day, I think you're going to get wholesale compliance with that. I think a lot of students are just going to leave, and that's essentially artificially creating a fixed term of sorts. Push comes to shove, if they don't leave, landlord needs to decide what they want to do with that because, I mean, in principle, they still have to pay the rent, don't they? And this is another perhaps a benefit of having room lets. That person will remain liable by themselves for as long as they stay in that property. If they really want that tenancy, you've got to consider why do they want that tenancy? If they're staying on because they just want to live in that property for another academic year, then fine, no harm done. You don't have to evict them. But yeah, if they stay, you want to evict them, the process of doing that is going to take you into the next academic year, guaranteed. So it's unfortunate. Again, you're just going to have to probably accept a void period.
Yeah, understood. I think just to expand on that as well, Ryan, I personally think exploring individual roomlets is worth it. Not just because if I mean it doesn't preclude you having a group as a landlord, and the group will still come as a group to look for the property. I think it's you're just executing that agreement in a different way rather than them signing a contract together. They sign individual contracts, and to me, that you know, it's not going to preclude you having a group. It just means that if someone wants to leave, they can without affecting the rest of the tenancy.
Hmm.
And I can see a vibrant market for kind of replacement tenants in terms of kind of it's probably a service that we would provide, helping landlords to find and fill a room, an individual room. So it just seems to me considerably less complicated, and
Mm.
it doesn't preclude you from having a group of friends who want to live
Yeah, I
together.
hear that they can all still live together, can't they? They just don't share responsibilities.
Yes. The someone's asked in the new sort of form of tenancy, or indeed in the current one, would there ever be any mention of sort of a duration of time, or will the tenancy just have a start date? You know, or is there any need to specify a sort of anything in relation to any
The
time
only
period?
the only time period mentioned is going to be the frequency of rent payments, so up to 1 month. Um, you can't have any reference to it being being a fixed term. And I suppose you have to kind of think what are the consequences of not applying of not obeying the law. Ultimately, it's going to come down to if you're ever found out, you could be penalized. But there's a big if there. If you're ever found out, I think we've seen this in Wales. I've referred to Wales already. They Rent Smart Wales, who govern the Welsh lettings industry, they think there's still a sizable portion of the landlord population in Wales who just have not obeyed the new laws. They're not registered. They're not using the new contracts, and there's just essentially like a shadow lettings industry that's going on. Now, I don't expect anyone on this webinar to be involved in the shadow PRS, but ultimately the law is only as good as if it's going, if people obey it. If there's wholesale non-compliance, it's going to be difficult to actually enforce any of this stuff. So ultimately what I'm trying to say here is if a landlord, an individual landlord, not any of you guys, if an individual landlord decided to put a fixed term in a contract and a tenant left in accordance with that contract, no one's going to necessarily know or get punished for that. And there are going to be people out there who are going to do that because they're not even going to be aware that the laws changed. Um, they're not on webinars. They're not getting advice from professional letting agents. They're just doing their best with their tenancy agreement from WH Smiths.
Okay, and I suppose what you could do is this: you could put in the tenancy agreement what the intention is, i.e., that the kind of the intention is to run the tenancy for a particular period. It's just the reality is that the tenant would be free to give their notice at any point within.
Yeah.
Yeah, yeah.
Yeah. So this is somewhat related to the slide because I talked about giving the pre-notice before the tenancy is entered into. Now, something that's been running in my mind is before a tenant signs a contract, they're given a copy of the contract. So if that notice was page one of your tenancy agreement, I think that would be compliant because they have received that notice before they've signed. I think that's okay. So yeah, there's no reason at all why you couldn't work it in that way. And then you've always been compliant. You've always given that notice.
Great stuff. So Ryan, I've got two more questions, and then we'll call it a day.
Sure, sure.
So this is a good one actually. So someone's asked, what liability would you have to the incoming tenant if they couldn't take occupation of the property because somebody was refusing to leave?
Well, again, this isn't necessarily a renters' rights question. This happens all the time. Ultimately, the landlord does face liability if they've entered into a contract that they can't fulfill. So the incoming tenant's losses could be claimed from the landlord. So
Okay,
let's say tenant turns up fully expecting to get a set of keys. They've got a rental van with all their stuff in it. They can't move in. It's foreseeable that they'll need to store that stuff. They need to get another rental van. They need to stay in a hotel for a few days. I mean, again, if we're talking about a few days, um, in the long term, if that tenant is quite clearly going to be evicted at some point, 3 months down the line, that then the tenant's going to have to find alternatives, and they can't just stay in a hotel forever. They've got to take steps to mitigate their loss. But in the short term, those losses will have to be paid for by the landlord. Because they entered into a contract that they couldn't perform. And ultimately, it's worth me saying this because I give this advice all the time. The tenant who is in the property will not be responsible for those losses at all because they've got every right to stay until they either leave of their own accord or are evicted.
understood. But your point here is that's not specific to the renters' rights.
Yeah,
That's
that
the current
happens all the
situation.
time right now. Yeah,
Yeah, but it's rare in the student sector because students tend to want to go ahead.
exactly,
Okay,
exactly. You're shielded in many ways from the full force of the PRS market. But like I say, I get this all the time.
excellent. Okay, last one. Someone just wants clarification around the two beds and HMOs. So, so kind of the could you just clarify the position? And so that you were saying that if it is possible for a two bed to be classified as a HMO, might
Yeah.
not be licensed as such, but it can be classified as a HMO, and then therefore ground floor A can apply.
Yeah, I think you've done my job for me there, basically, which is that so ground for a one of the preconditions of using it is that the property is a HMO, but we're not talking about an additional HMO or a mandatory HMO. We're not talking about licenses here. We're just talking about the legal definition of a house in multiple occupation that requires two households. Interestingly, probably worth me mentioning this, a couple counts as one household. So you could
Okay.
so that could actually cause problems if you're letting to say boyfriend and girlfriend. Um, yeah, and I mean it's and I don't it feels quite intrusive to have to ask like are you two in a relationship? But basically if they say we are in a relationship, that's one household. You might
Okay.
have a problem. Um, if they're just friends, that's better.
Excellent.
Okay, if we it
Okay.
can be difficult to tie these things down.
No, understood. So the last one that came in was just Joe Helworth saying thank you, and I just like to reiterate really, Ryan, it's been absolutely fantastic, both in terms of the presentation, what you've covered, an awful lot of clarity on the specifics. But what I've really appreciated, and I know our landlords will, is that practical advice because I know that a lot of them had questions about what they can do. So I think it's given people a real tangible idea about how they can move forward. So absolutely brilliant. I'm sorry to have kept you on
Oh,
for
it's fine.
longer.
I'll forgive you. Don't worry.
But just the number of questions. We didn't actually get through all of them, so I'll follow up with some more. As I said, we'll be sharing the recording and the slides, and you can provide your contact details if you like, if you want people to get in touch with you, because in terms of preparing tenancy agreements and so on, that's something that I'm more than happy for people to contact you with, and you can kind of explain all of that and how that might work. So yeah, thank you again. I'm going to shortly sort of press end on the webinar, and that'll bring us all to a fairly abrupt end.
Great. Thanks very much for your time. Appreciate it.